And I bet if we surveyed the room, probably just about everybody in here would know somebody, have a family member who's been in a nursing home, had a client who's been in a rehabilitation center. And these are the types of cases that touch families. There's a lot of trust given to that facility to care for the loved one. And when that trust is betrayed, and the nursing home or the skilled care facilities they like to refer to themselves doesn't uphold this obligation, the consequences can be real. Health actually has the specific definition of deficiency, and in a nutshell it means putting the resident's care substantially at risk. It can mean a fall, it can mean dehydration, pressure ulcers. Those are examples. Those are specific, actual specific definition. So some initial considerations in every case. I like to start with the family. I mean, I think that the family and the life story tell you everything you can know about your client. This is part of putting a face to the name, not just a Medicare or Social Security number to the bed. When I meet a new client, it's usually the grown children will come in talking about an aunt or a mom or a dad who's been injured. And I want to know their life story. I want to know when they're married, I want to know where they went to college, where they met, and I want pictures. Bring me your shoe boxes full of old photos. They really mean a lot. I want to know how involved the family was, how much time they spent together, how much time the kids spent with their dad or their mom or whoever this person was that was injured. And then I want to know about the defendant. There is an overwhelming web of corporate shells that you will find when you start getting into these cases. You will find there's a holding company that owns the property. You'll find that there's a company that manages the nursing. There's a company that handles the food. There's a company that leases the property. And they're all subsidiaries of some other company. And so the first thing you have to do is you have to get down to business and start figuring out this web. Putting the flow chart together and organizing who is controlling what and who do you have to sue and how can you basically hold them accountable. So the other things I like to learn about the defendant. I do a search for all of their marketing material. They advertise in journals and they advertise in newsletters, things like AARP. They are out there, and some of the things that you'll find are just absolutely golden because they can help you set up the rules of the road, and everywhere in their materials is quality care, compassionate, skilled nursing, and you can start to draw some very, very stark contrast from the beginning. I also think about the fact initially when you're getting to know your client, and you're getting to know this case, that you probably have a sick person who is injured or who is a vulnerable person to begin with, who probably didn't have a lot of years left. That's why this person was in a nursing home at the beginning. But it does not mean by any means that you can't prove your case, and that this case is being about the cause of action. And this is where I think it's important to think outside the box a little bit. These cases are not just medical negligence cases, not by any means. There's a lot more that you can do. One of the absolutely most important cause of action is the vulnerable adult statute, RCW 74.34. And the vulnerable adult statute, which I'll go through it here in a minute, provides for attorney's fees, costs of litigation if you prevail in party, and also has an entirely different standard in medical negligence. You don't have to prove causation, you don't have to prove actual harm. Also, I think it's worth mentioning, if the facts indicate great negligent hiring, supervision, and retention time. There's a great law in this area in Washington State. I put some of it in my material. And often you'll find that the people who have been hired are poorly supervised, or perhaps they're poorly trained. And this will give you a cause of action that will help you survive summary judgment, because you don't need to prove standard of care, you don't need to prove causation. It's completely separate from the medical elements of proof. So it's something I'd like to add to my complaints. The vulnerable adult claim really departs from the medical negligence claim. This is really the kind of meat of it. Here, you have two definitions of neglect. One is a pattern, or a pattern of conduct or an action. And this is the one that I think is most important in most cases, and it's also easy to prove. It's a single act or omission that demonstrates a serious disregard for the consequences of such a magnitude as to constitute a clear and present danger to the vulnerable adult's health, welfare, or safety, including but not limited to conduct prohibited by R.A. Now, this is the devil's in the details here. It does not say that the conduct actually had to cause the harm. The only thing that is required to meet your burden of proof here is that the conduct actually put the person at risk to health, welfare, or safety. I think that's an incredibly important distinction. You don't have to prove standard of care. You don't have to prove causation. And you don't even have to have actual harm. The statute also lets you bring a claim for abuse. I know that's too small to read. The definition is a lot more involved. It's in the material. You're probably not going to see abuse claims as often as you will with claims. So these claims can be brought because the vulnerable adult statute by the Department of Health has enforcement capability. They can bring a claim themselves or by civil action. And here's the good stuff. Action, if you prevail, you're entitled to your attorney's fees, costs, and filing fee of all the last. Here again, $34,200. If you prevail, you get actual damages, cost of suit, reasonable attorney's fees. And one of the things that I think is important to point out, there's the case, I've talked about the material, Conrad versus Alderwood Manor. It's a case out of Spokane, and it's a case brought by attorney Mark Camerton in Spokane. It concerns concurrent causes of action, medical negligence, and the vulnerable adult statute. And the Court of Appeals got a great verdict for the case. And on the verdict, on the special verdict, the jury awarded damages for negligence and also actual damages for neglect under the vulnerable adult statute. Defendants naturally took it up to the Court of Appeals. The Court of Appeals says, well, there are two separate causes of action, there are two different elements of damages, and you're entitled to recover damages for each statute. RCW 7.70, which is medical negligence, and RCW 7.44. So huge, huge win. And what that tells you is that you can basically recover overlapping damages for double damage in some cases if the evidence permits it, and attorneys